everyone. My name is Yunusov. I'm the host of the Yunusov Question, and this is yet another great interview from the Yunusov Question, this time with Barry Weintraub. Hello, Barry.
Hello, how are you, Palat?
I'm very good. Barry is a very experienced litigation lawyer in Toronto, and I understand that you were called to the bar in 1989, if I'm not mistaken.
That's correct.
Okay, so being called to the bar in the 80s, well, the 80s were on the way out, but still it counts as the 80s. How was it different than, I'm sure you experienced sort of as an observer calls to the bar in more recent years, your articling students, your junior associates, and so on and so forth. What is it different? What is it different about being called to the bar today from being called to the bar in 1989?
Well, if I got called to the bar today, I'd be really old for the beginning of my career. But back then I was young, and I think like everyone else, you're young and you're optimistic. And I think I started actually as a summer student in '86 at Stikeman Elliott. Had a fantastic experience working with John Supinka on public inquiries, constitutional cases, libel actions. It was really great fun. Work was fun. And I have actually always felt that work is fun. I still feel that way about it. I think one of the things I see today, and a lot of this comes from social media, but I think there's a lot less optimism among younger lawyers today about the future and about whether they can have fun practicing law. And that I think is sad, because to me it's always been an adventure. It's always been about learning new things. You get to help people, you get respect, you get to work with language, you get to work with people. It's just a great job. And so I would say that there's a general sense of a bit more pessimism, a bit less optimism than in the '80s when I started. But that isn't really that new. It changed, and it changes with situation in the world. Early '90s, GST came in, the real estate market crashed, and all of a sudden, people weren't as optimistic as they were in the late '80s. Then what happened is, because of the market changes, there was all this litigation that got started in the '90s, and then there were delays in the court. And the delays in the court lead to loosening of summary judgment motion rules. And so then there's a big move to do summary judgment motions, and then there's a swing back away. So there pendulum swings over time that repeat themselves and we as lawyers are not immune from what's going on in the world around us. So I think if you look over the last 5 years of the world, in a lot of ways, there's been a lot of bad news. There's been a lot of controversy, controversial leaders, controversial people getting headlines, and controversial events that have, I think, made people more angry, more expressive of anger, and a little bit not as nice in terms of being respectful to others. And so now what we're hearing, and I think in courts, what we're seeing a lot of is civility is the issue now that people are talking about how uncivil it is. And I find that actually quite an interesting thing, having gone through 4 decades or 5 decades of different types of lawyers. In my experience, actually, when I started, all the lawyers knew each other, and they were gladiators, and it was kind of a rite of passage to to get beat up on and to survive. And you prided yourself on surviving. And I had a lot of good lawyers I worked with who sort of taught me the ropes of how to deal with nasty lawyers. And the best advice I ever got was working with Paul Rouleau, taught me that what you do when you get in a war of words with someone is write for the judge. Judges don't want to hear that nonsense. So just appeal to the better side of the other lawyers, write for the benefit of the court, encourage the other side to cooperate rather than making noise. And it works because if the other lawyer is smart, they will realize that judges don't want to hear bickering, and they'll be more constructive. If they're dumb on the other side, then what they will do is continue to fight. And so it's people can be as nasty as they want, but they're going to lose more often than not. And that's what I think lawyers need to understand today is if you want to win, when it's about winning, the smart lawyer will be civil, and it's less effective to be nasty. The other thing I want to say is that over the years, what I've found is you can't be all things to all people. You really have to, at some point, learn about yourself, learn who you are, what you can do and what you can't do. And you can't please all people. And I think a lot of the problems with civility comes from clients. There's a lot of clients out there who don't want civility. They want somebody who's going to be a tough guy, who's going to beat up the person that they are fighting with. And so they will find a lawyer who will tell them what they want to hear and will do things the way they want to do it. And if you as a lawyer are predisposed or have been trained or learned how to fight, and fight aggressively, then you will come across and make a very good impression with a client who wants a lawyer like that. And that's so it's not so simple as to say all lawyers should be the same. I think also, looking at this from a broader socio-political perspective, there's a lot of people in our society who are not privileged, who are underprivileged, less privileged on the outside. And when I went to school, the concern was that courts were about and for privileged people. And it's too conservative. And it's all about rich people fighting over how much money they're going to get in litigation, as opposed to big issues of social justice where people get left out. And I guess my point is, if you're fighting for someone who is in a bad way, who's downtrodden, if you're not a little bit angry, are you really doing your job to well represent what your clients are experiencing? We are here as professionals doing a job for our clients in trying to speak for them. In a democracy, that is a true privilege. It's something that is a responsibility, because if people cannot speak for themselves, they rely on us as lawyers to get their point of view across. Sometimes a little bit of anger is, in my perspective anyway, warranted and necessary. And I think we lose sight of that. And let me give the classic example. I'm going to weigh in on the Joe Groya case, where he was defending a very unpopular person charged with criminal offenses. His defense was that the prosecution had been overzealous. And so he would make objections, and the prosecution rose to the bait and made it turned it into and took it as a personal attack and got really upset about it. And the fight was on. And that, in a lot of ways, played into the hands of the defense strategy that there was the prosecution had gone overboard. And in my view, you have to keep in mind the context of it. You can say, in fairness, that's not a very good legal argument. But you know what? A lot of times, if you're representing unpopular people, perhaps that is the best defense that's available to you, and you run with it. And a good lawyer will make sure that by the time you hit the courtroom steps, you frame the issues in a way that puts your client in the best position possible. And someone who's fighting the establishment is a different way of doing things. Sometimes that works, sometimes it doesn't. It really depends on who you're representing. And I think that's something that there isn't one way of doing lawyering that is the only good way and the only right way. And there is not a one type of lawyering that fits all clients and all client situations and every case. I think as lawyers, we need to be adaptable a bit, have more than one face, more than one trick, more than one tool in our toolbox for how we present cases, how we think about cases, and how we prosecute them.
Wow. This is so much to digest, and it really strikes a chord and rings a bell, and it's moving, and I think it's probably the best 10-minute graduation speech to an outgoing law school class that I've heard. And I really hope that law schools in Canada watch this show, because the law students really need to hear this, and junior lawyers. I would say up to the 5th or the 7th year of practice, this is definitely gold. What you just said, it's really, really important.
I mean, one thing I can say that there are others around who will remember this, but the nastiest lawyers I ever came across were the ones who were 15 or 20 years older than me when I was a puppy. And it was kind of fun in a way to be able to go to battle and survive. You had to be a little bit strong. You had to be a little bit self-assured. And I think that is another aspect of what I see in the legal profession today, is that a lot of us are uncertain of our future, and that reflects in the way we think of our job, think of ourselves, and our preoccupations. From my perspective, I think that we should keep in mind that our job as a lawyer to speak for people, to help people with their problems. And what that means is we need to focus on our clients' problems and help them solve them. Full stop. That's our job. To do that well, I think we have to take care of ourselves. We have to be a person who can give good advice to clients who are in need. And in a way, I would say that's sort of the full stop. That's where our job starts and ends. But in doing that, we have to take care of ourselves so that we can do that for our clients. Everyone in the world, has some mood issues. I have happy days. I have sad days. Everyone else does too. We all have our problems. What we're lucky enough to do is that people come to us when they're in need, and I think we have a responsibility to help our clients, and that means taking care of ourselves. It means, I think, a certain amount of mental toughness is required to be able to put your own problems, your own issues to the side and do your best for your clients, because that's what it's all about. It's why we have all chosen this profession, is to help our clients. And it's not really about ourselves. And I think we should keep that in mind and try and make it less about ourselves and more about our clients. We're lucky people.
We are. And we are lucky because we're also survivors, at least those of us who are still around. And I like the idea of survival as an element of training. And it sounds probably counter to the current thinking or to the trendy thinking, but I don't think it's as cruel as it sounds at all. I think, for example, that you cannot know civility until you saw incivility. So junior lawyers who never see incivility, how can they really know civility? This idea that you need to know the bad to understand the good is straight out of Old Testament. I think it's really old. And we live in the age where mentorship is much less available. And of course, you want to deal with incivility when you have a mentor at your side who can help you identify what happened, break it down, cope, and so on and so forth. So I want to hear from you. And I'm sure you've had mentors like that. You worked at top-notch firms all your life, and then you started your own top-notch firm. Uh, Tell me about the worst example of incivility that you experienced as a junior lawyer. You said that you had quite a few.
Uh, the classic one I remember was a great lawyer named Ian Outerbridge, who was the big man on campus at U of T in the 50s, was one of the leading lawyers, was former Justice Farley's partner for a while, I believe. A great lawyer. And his style was bombastic. I was involved in a case, and it was a multi-party case. We were working with another of the parties together and brought a motion that the other party, that was our ally in the action, was not able to bring. And so Mr. Outerbridge wrote me a nasty letter saying the judge had ordered no motions to be brought, and you brought the motion. And then he ended it with the line, you in bold block letters at the bottom, you'd be well advised to exercise caution in your interactions with members of the opposite gender in light of the no means no legislation that had just come out in the early 90s. I was dumbfounded by this a little bit. And I was working with Peter Howard at Stikeman Elliott at the time. Peter was and is very knowledgeable about famous quotations. And I had seen on a letter he had written a quotation from Shakespeare. So I stole it and wrote back with a preamble to my letter that said, "There is no terror in your threats, for I am armed so strong in honesty that they pass by me as the idle wind, which I respect not." That's from Act 5 of Julius Caesar. Apparently, I'm not a Shakespeare scholar. I want to point that out. I'm a prairie kid, but I used that and then said, your rhetoric is as offensive as your remarks are inaccurate, and then simply responded to what he said and said, we brought the motion and we're entitled to bring the motion, and we weren't blocked by it. That letter brought a retort from Mr. Outerbridge that was even better. He said, something about past wind being very idle. And it was an incredibly clever response by him. Um, this was fun, is I guess what I'm saying. It was harsh, but I survived. We didn't let things bother us that way. If you did, you had no future, really, was the way things were looked at back then. And the old time lawyers were gladiators. They fought with each other, sort of like the old Bugs Bunny cartoons with Sam and Ralph. The coyote is out hunting, and Sam the Ralph, he's Ralph, and Sam the sheepdog is protecting the sheep from the coyote. And so the sheepdog beats up on the coyote all day long, and then at 5 o'clock the whistle blows, and they walk home together and say, "See you tomorrow, Sam." That was kind of the ethic in those days, and they took it to heart. These lawyers, I heard stories from Mr. Supenka about Walter Williston, would always invite opposing counsel out for dinner whenever they were at the Supreme Court in Ottawa, and they'd have dinner before. The reason Walter Williston did that is he was very experienced at drinking, and would drink the other lawyers under the table, and they would both go home very drunk. And Walter Williston got an advantage from that because the next day he could function and the other lawyer couldn't. Um, I don't know if that's actually true or not, but it's sort of part of the lore that I learned. You learn stories about people, and how things were done. The lawyers all knew each other. They respected each other. They knew each other's weaknesses and strengths, and sometimes they didn't respect the others. They said what they thought, and you knew each other. I think today very few people know other lawyers really well. You know a few people, you know a lot of people very loosely at first, but it takes a long, long time to get to know people really well. And that's where we have lost a bit of collegiality because as an articling student, I got sent on motions, discoveries, assignment courts all by myself. I did a trial, a small claims court trial all by myself as an articling student. We got in court a lot more. We saw other lawyers. We were going up against more senior lawyers, and you learn from them. And, I remember the senior lawyers that I was on the opposite side of cases who would help me. And that always stuck with me. It's something I've always tried to do is help other lawyers. And part of that is because I remember what it's like to be thrown in, and you learn on your feet, you make some mistakes, but a mistake is not the end of the world. A mistake is a learning experience, and you get better from it, and you vow not to make the same mistake again. If you never make mistakes, then you never learn. And I think that is a comfort zone that people don't have. And look, even from throughout my career, there are some people who love going to court, and some people who really don't. They get nervous. They have to push themselves to prepare, and they do it, and they find a way to make it work for them. I knew one lawyer that I worked with who would throw up every morning before going to court, but would win, would do the work necessary to overcome that and be able to function. Everyone has their own issues, and it is up to us to find a way to overcome them and do the best we can for our clients.
I feel like modern stories of incivility are so petty and low caliber, And modern perpetrators of incivility are so petty and low caliber compared to the perpetrators in your stories. In
I,
your stories, it's so literally highbrow. I want to
I,
experience that.
there's another one from the mid 90s that I remember was circulated, a discovery transcript of two lawyers, and one of the lawyers was a very prominent litigator, and wasn't particularly well liked. And the what the transcript showed is this: there was a dispute over some question and a bit of an argument on the record. And then this line: let the record show that opposing counsel is pouring coffee on my papers. Let the record show that he's doing it again. Um, that lawyer who poured the coffee got disciplined. Um, and and I remember reading this, and I thought, what's the real story behind this? So I picked up the phone and I called the lawyer who had poured the coffee on the other lawyer. And the interesting thing about that story was what he told me is he said, I kind of lost my temper. We'd had a firm retreat scheduled for that Friday morning, and he had opposed, and he wouldn't allow an adjournment of a discovery, and it was in the middle of the summer, and I was really angry, and I shouldn't have done it, and I lost control. And he said, and I really regretted. He was disciplined by the Law Society, and he apologized, and it passed. But he also made an interesting comment. He said, the interesting thing is how many calls I got from other lawyers congratulating me for doing it and saying they wish they'd done it themselves. And look, this is a stressful job. It's something where the other lawyers have a job to do as well. Their job is to advocate for their clients and to make your client look bad. You're just the representative of your client. None of this is personal. I was crossing my first case as a lawyer almost 35 years ago. When my first day as a lawyer, I had to put together a motion record to dismiss for delay an action that had been alive for, at that point, 12 years. And so I went through the entire record and did an affidavit setting out the record. And I was cross-examined. And the lawyer on the other side, Bill Trudell, was a very prominent criminal lawyer, used to doing a lot of jury trials. And so we were arguing the motion. And one of the arguments that Mr. Trudell made was to criticize the plaintiffs for not swearing affidavits on the motion to dismiss. It was a libel action. And as he's doing this, he said, instead of the defendants swearing their own affidavits and submitting themselves to cross-examination, they set up a wet behind the ears first week lawyer to do the affidavit for them. And as he's making these submissions to Justice Rutherford, he walks by me because jury lawyers will pace back and forth across the courtroom. So he's going across the courtroom, and as he's saying this to the judge, he turns to me and winks. And I realize then this is all a play. It's all an act. It's kind of a script, and it's a script that you don't know what's going to happen next, and you improvise and you make up the script, and that's the fun of this job. Is that uncivil? I didn't take it personally. I didn't think it was uncivil. I thought it was actually very clever. And we won the motion, got the case dismissed. And unfortunately, the Court of Appeal disagreed later on and reinstated the case. And it ended up my first trial, and we lost that trial. It was a 4-week trial that we lost. It ended up, this case went to the Supreme Court of Canada. Losing a trial is a horrible experience that I recommend to every lawyer, because
I
what you
did
do,
it.
if you haven't lost, I mean, if you haven't lost, you haven't learned. And I learned a lot. Sheila Block was the lawyer for the plaintiff,
Uh,
did a fantastic job. And you see the difference that lawyers can make in a trial. And I learned a lot from watching Sheila do perform and do a fantastic job. You know, what you do, I think, over time is you want to win more than you lose. You better win more than you lose. And really, if you think about it, because you can always settle a case, you should win most of your cases. I also think, though, that if you win every single one of your cases, then it probably that you take to trial, then you're probably selling your clients a bit short. Not every case needs to settle. Sometimes there's cases where it could go either way and you should take a shot at it. And you discuss the risks with the client and take a shot. So to me, I guess the ideal outcome is your record should be 75%, 80% wins, because you should be smart enough to avoid ones that are sure losers. Settle those ones. Change, do your best to put forward the mitigating facts and settle. And that's really what good lawyers will do. And that's why you can win more often than you lose. But if you win everything, then you're probably settling cases too easily. And so I think that's sort of a way to look at it. Um,
you know, go ahead. I
so
fear interrupting you because it's a river of gold, and who am I to block it?
well, what have your experiences been with civility?
Well, first of all, I really liked your story about the wet behind the ears, wink, wink episode at the motion to dismiss for delay. And your sudden realization when you were only in your first year, I guess, of practice, that everything, it's all a play. And, unlike you, it took me years to realize the application of these words from Shakespeare to our profession. And the words are, and they are pinned to my Twitter profile, all the world's a stage and all the men and women merely players. They have their exits and their entrances, and one man in his time plays many parts. And these are my probably by far most favorite words from Shakespeare. And I think your story is really an illustration of that. I certainly had a lot of experience with incivility, but the trend is on the decline. So the longer I practice, the less incivility I experience. And I also acknowledge that, of course, I am not a member of a group that is normally the target of incivility more than others. I have a pretty intimidating appearance, and I certainly benefit from that. But also with experience, and with the more people, the more lawyers, the more colleagues the less of that you experience. The stories that you told, I don't think I wouldn't consider them incivility. If that happened to me, I would consider that to be something fun happened finally, some to interrupt the drudgery of this day, and especially an opportunity to exchange Shakespeare quotes and letters. Although clients don't like paying for that anymore, for that use of our time. And so to me, it always really has been quite methodical, and I would treat opposing counsel that don't want to be good to me, I would treat them as forces of nature. And you don't get offended at forces of nature. You don't get offended at probabilities. You don't get offended at accidents. You don't get offended at random events. So you just plan for them. You prepare for them, and then you handle them. I don't take things personally. I have very thick skin. And my problem is the opposite. I worry about other people considering me in civil because I feel I'm a little bit too thick-skinned. I feel I lack emotion to the sufficient extent, and maybe that's a shortcoming of mine. I feel that emotion, which I evaded a lot in my early years, I feel it actually is a tool to advance cases and to promote clients' best interests because it helps settle, it helps negotiate, and it helps also understand the facts better. So I'm learning, I'm developing that side of mine. Maybe I will become more sensitive to incivility as a result. I don't know. We'll find out. One thing that I wanted to ask you about, we talked a lot about the relationship between a counsel. I want to talk about your experience and your relationship with judges. And if you have any stories that you want to share over the years, how have judges changed over the years? You have this long-term view on that topic, and how has the relationship between the bar and the bench evolved over the 35 years of your career?
Um, well, let me start with recent times, and say post-COVID. Um, right now, the motion wait time is crazy,
Yeah.
and there's an incredible pressure that everyone in the justice system is feeling. And I've seen this with judges. They are really hardworking people. They are trying to do a job. I have seen some of the most impressive judging. I was doing an appeal in a provincial offenses court, um, and they were hearing appeals of people who, one of the appeals was someone who pled guilty and paid a speeding ticket, and then tried to get an appeal of it and reopen it because they found out afterward that their insurance was going to go up. And so they brought an application to court, got had it dismissed, and tried again at the appellate level. What they lost, as is predictable, but what I was very impressed with was that the judge, it was Justice Cooper in Newmarket, took the time to explain why to that litigant who was self-represented, to explain why it was that they lost their case, and treated them with respect, treated everyone in the courtroom with respect. And yet the lists were long. Everyone had to wait. My appeal didn't get heard until 2:30 in the afternoon because there was all this stuff, and we didn't get finished. And it is a system that needs to be reorganized, needs more resources, and everyone is struggling under that. Every judge is feeling that pressure because they're all wanting to do a good job for the litigants, for the public, and they feel frustrated. And that frustration is often very visible, and yet when they get to focus on the issues, they focus on the issues and they do a good job. I think we are very well served by our judiciary, and I think there are, as a whole, I think there are some judges that are definitely better than others. Some judges who are um, sometimes let their own frustrations show through in their demeanor in court, and I think that's unfortunate. But that that's part of one thing I was taught early on is the first thing you do when you go to court is find out who your judge is and know that judge. Do some research on the decisions that judge has decided. Talk to some people who've appeared before that judge, if you've never done that before, so that you're prepared, because your clients want you to win, and there are different ways to win. I saw recently Justice Montgomery just passed away, and there were all kinds of tributes to him. Um, he was a judge who was a very, very good in some ways, but he was also a judge who made up his mind on a case before you'd even walk into the courtroom very often. He was still would listen and give you a good hearing, but you always had the sense that you knew where he stood. That is, with some judges, it's a good thing. Other judges, it's not a good thing, and it really depends on their demeanor. I think the foremost quality that a good judge has is respect. They respect people and treat them respectfully. And to me, that is the essence of the system of justice, the administration of justice is to treat everyone with respect, even as we're throwing the book at them or giving judgment against them. It's will the person who is the loser in a case feel like the judge listened? Will they feel like the judge treated them respectfully and disagreed with them? And it is not always the case that litigants who lose blame the judge. And that's where if you realize that, a friend of mine told me a story of a labor arbitration that he lost, and it was a hard-fought battle, and the client lost, and after came up to him and said, I know we lost, but I just want to say thank you because you spoke up for me and you fought for me. That's what we do, and that's the what makes the system of justice work. And I think it's a good thing. So I generally think the judges are good. I think I've had the luck of working with a lot of people who ended up being judges, both at Stikeman Elliott and then at Janae Murray and then at Heenan Blakey. And they're every one of the people that I knew that ended up becoming a judge was a decent person. And they were a smart person, and they were a person who cared for their job. I want to go back to something you said, Pulad, earlier in about survival. And I want to disagree with that. I think survival is something that you do, but I think we need to set our sights far higher and better than mere survival. What we need to do is have fun. We need to thrive. We need to feel like we're in charge of our destiny. And I think that's where if you're a young lawyer, decide where you want to be and what you want to do and how you want to make your mark, and keep that in mind and never waver until you reach it, or don't reach it, because you never always reach your goals. If you do reach your goals, then set new and higher ones, because what this is about is striving to be better, striving to learn, striving to develop. It's constant improvement and learning. And I learn something new every day. I learned something new yesterday. I learned something new from listening to you. You always learn, and you learn from your colleagues, you learn from your clients, and you learn from putting the work in. And I think that's the other thing where I think there's been a big change, and I think it's tied in with the pessimism. When I started, I was working at a big firm at Stikeman Elliott. It was one of the firms that was considered to be a place where hardworking people were at. And the interesting thing was there were no targets. There were no one ever said you have to stay. No one ever said how much time you had to put in. What it was you had interesting files, and you wanted to do a good job and win them, and you wanted to be the best lawyer you could be. and you're working with other people who are smart. And let's face it, as lawyers, anyone who can get into a law school is a smart person. We're all smart, and this is a job where you also, if you're a litigator, you want to win. You take two smart lawyers and put them in court on a case. The odds are that they'll end up sawing them off. If you want to do better than that, what you have to do is work harder than the other person. You have to know every aspect of your case, be totally prepared, and throw yourself into it. If that means doing some research to find that one case is going to make the difference, or thinking about how to cross-examine, or just knowing the file better, you do what it takes because you want to be good. You want to live up to the responsibility of being able to argue a good case. It's not about I'm sure I gave up some social opportunities to work a lot of times, but I never felt that I was forced to do that. I did it because I wanted to. My colleagues were doing it, and I didn't want to let the team down. And I loved what I was doing. And I want to mention another thing that I learned from Peter Howard at Stikeman's. He said this probably about 30 years ago to me. He said, practicing law is actually an easy thing to do if you're content to be mediocre at it. It's not that hard to master if you're content to be mediocre. But if you want to be really
I agree
good,
with this so much. This is such a good point.
you have to work hard. And
Yeah.
the good lawyers will work hard. You can't work hard at something if you don't love what you do. If you don't at least love or respect the law a bit, like your clients, want to win your clients, and have subject matter of your files that interest you. If you're stuck in a job that is uninteresting, do something different because
Yeah.
you won't last if you hate it. And that's the one thing I've seen over the years is you come back to survival. To me, survival equals succeeding, because if you want to succeed, all you really need to do is like it enough to stick around, and things get better. You learn more, you get more competent because you never forget the lessons you learn along the way.
Absolutely. One other thing that strikes me about your career is how you've had this long-term view of many different firms. Law firms are, of course, one of the most common forms, or at least one of the most, I guess, desired forms of organization of lawyers to practice law together. And you started at Stikeman's in 1986, and then after more than 8 years, you moved on to Genet Murray, where you stayed for 5 years. And I think that firm is still around, right? Genet Murray.
Yeah, what happened was at Genet Murray, we had sort of three different areas. We had a commercial litigation group, we had a municipal group, we had an insurance defense group that did a lot of school board and lawyer defense work, and we had a labor practice. And we ended up merging with Heenan Blakey. So 17 of us went from Genet Murray to Heenan Blakey, mainly in the commercial litigation and labor groups. The insurance defense lawyers realized that a big firm with high overheads wasn't what their clients as insurance companies would be willing to pay for. It didn't make sense for them because insurance companies crush clients on rates, or crush lawyers on rates. So you can't have the expensive overhead. The Genet Murray name was for those around. was a very well-respected firm and name, and they wanted to continue that name out of respect for Genet and Murray, and so they continued. The first Genet Murray partnership wound up, and they used the name to start their new partnership and continue on, and they've been very successful. And a lot of them, my former colleagues, are, again, quality human beings and quality lawyers. They're really smart people. Genet Murray was formed when I was articling, and I remember seeing it. Pierre Genet was one of my heroes from afar. I grew up in Alberta, but it was around the time of the Charter of Rights and the constitutional battles. Pierre Genet was the I understand he actually wrote the charter. He was very tight with the federal government. He argued the patriation reference was a treasurer of the Law Society, fully bilingual, and lawyer for Ontario Hydro, a really top-notch lawyer at Castles Brock in its first heyday. And all of the Genet Murray lawyers basically came from there, from the litigation group there, and set up this new firm to do things differently, a litigation boutique. And it was an interesting idea, one that had some appeal to me. I went there along with at three other colleagues from Stikeman Elliott in '94. Another two joined us a couple of years later. And again, it was what was interesting about it was the different styles that different lawyers had. I mentioned Paul Rouleau, who was you know what Paul Rouleau is like if you've seen him on television. He's incredibly smart, incredibly hardworking, and also very nice. A really nice person who cared for other people. There were some great lawyers. Eric Murray was one of the legends of the bar. He was Canadian bridge champion for 35 years in a row, went to world championships, personal friends with Charles Gorin and Omar Sharif, and probably did more appeals in the Court of Appeal than any other lawyer that ever existed. And he didn't really take cases. He took crusades, and threw everything into his cases. And he was sort of old style curmudgeon. He was a curmudgeon on the outside with a heart of gold. And the typical, the one thing I remember him saying to me, he called me motor car because my initials were BMW. And one time he said, motor car, that letter was pretty good considering the source. And it was he was sort of that type of person who would mix insults with praise, but he said it with a smile and a twinkle in his eye, and was just a great lawyer. I remember one case we were bringing an injunction against a bank that had shut down a construction company, a big construction company, 2 weeks before Christmas, and so it was an injunction. We ended up getting a temporary injunction, and then the matter resolved. But what I remember is the letter we wrote, and it was a tour de force of understated but heavily rhetorical excess, understated rhetorical excess, in which he basically said, "You realize that there are hardworking families that you're putting out of work just before the holiday season." And then at the end of the letter, he added, "P.S. Congratulations on achieving record-breaking profits for the last quarter." Just to me, a brilliant masterstroke, and And that was the type of lawyer he was. He was always thinking, and was at this point, he was in his 70s already. And he was also a stickler for the English language and for grammar.
Mhm.
Um, Working with Eric Murray, I found myself becoming more and more like him. And it scared me because nobody in Alberta, where I come from, um, takes care to avoid ending their sentences with a preposition. Um, and he did, and he taught me to speak that way. Um, when I left Jenny Murray at the end, and Mr. Murray continued on for a few years after that, I realized I'm not Eric. I can't ever be Eric because I don't my personality isn't well suited to being bombastic. I've tried it at times. I do try it at times. It's a tool, but it's not really me. And I think for young lawyers, what what you need to figure out, and you can't figure it out for the first 5, 10, even into 15 years, is what is your best self? Which personality or which you is the most effective? Which one do other people like more and listen to more? Um, and you've got to know who you are, because if you're faking it through your whole life, you'll never ever be good at it. If you know who you are, figure out what your strengths are, and and put yourself in position where those strengths can actually help you. I think that is an important aspect of growing as a lawyer. The first year or so as a lawyer, if you're a litigator, you learn the rules and you learn the cycle of litigation and you learn the interplay. That comes a bit later. Man. Until you've done a trial, you
Mhm.
don't really know what discovery is about,
Yeah.
because you often do the discoveries, your first discoveries in your first years, before you even have done a trial.
Of course.
And there are few enough trials, but once you've done a trial, you know what discovery is about, and you can do it better after that. So you learn the cycle of litigation, then you learn how to deal with clients, how to give opinions, which is a real difficult thing because you don't want to get it wrong. And yet you want to give clients good advice, and you want your clients to be happy, and you want the clients to have a good result. And those 4 or 5 different things pull you in different directions. And it's not an easy thing to master. What you have to realize is you can't tell clients what they want to hear. But what you do kind of owe clients is your opinion. And I think as a lawyer, we shouldn't be afraid to give our opinions, because they are just opinions. You can be wrong, other people can disagree. But if you don't have an opinion, you're not really giving your clients what they need. Your job is to help guide them to make better decisions. So once you learn that part and how to deal with clients, then I think, and once you're dealing with clients, you learn more about yourself. Which mannerisms, which way of dealing with people is going to get you more clients, is going to get confidence from your clients, and which things are not, and which things do you not feel comfortable doing, and you learn more about yourself. And sometimes there's some harder lessons to be learned in that. I know a lot about my own weaknesses. I keep it a secret. I'm not going to tell you any of them, but I know them, and I try and avoid situations that cause those weaknesses to come to the fore. That's a trick that you do in as you get older. The other thing you can do a lot is anticipate. I was listening to Cynthia Keel's interview which was very good. I know Cynthia, and she's a great litigator and a really fully together person. And what she said, and I totally agree with this, is the more experience you get, the more you can see patterns, and you have a sense of what's going to happen. And when you have a sense of what's going to happen, the easiest thing to do is to get in front of the parade and try and change the route a little bit. That's really what you do. Is it's not a predetermined outcome.
Mhm.
It's an outcome that is likely, but for your interventions. So your case, when you get to trial, should always be a better case than the case that comes in the door when you start. And we're like symphony conductors. If your trombone is off key, shelve it. Bring the other parts of the symphony to the fore, and orchestrate the message that you're giving. Avoid focusing on the weak parts of your argument. You confront them, sure, but tell the story in a different way. Make the issue an issue that you can win on. And that means know when to give in. Don't be too stubborn. Don't insist on arguing everything. Pick your spots. John Sapinka was widely regarded as one of the great lawyers. What I always heard from everyone about him and saw it was that he had a knack of getting to the point right away. And saying things in a very straightforward, what's the justice of the case sort of way. Mm-hmm. I went to the Supreme Court of Canada on his last appeal before he got appointed to the court. It was a Competition Act constitutional case, and he started his submissions with, my lords, my ladies, my argument can be summed up in one sentence. The civil remedy provision of the Competition Act is a valid exercise of the general branch of the trade and commerce power. And he said it sort of 3 words at a time so they could write it down. And then as he's doing that, one of the judges says, I suppose you want to see that in our judgment. And Mr. Sapinka nods and says, it's a good sentence. And that sentence was there at the end. That's the essence of good advocacy, and it takes a lot of work to be able to bring things to their essence. What is the justice of the case? What is the real argument you want to make? And make a good argument. One good argument is better than 3 okay ones. And sometimes the other arguments detract from the good ones, because you can't, keep it simple and focus on what the just result is. There's, I think, an element of the law is not our master as lawyers, as a society. The law is what justice requires. And you win a case by the justice of the case, and the law follows. It's nice to have cases, to know what has been convincing to courts in the past, and that helps. But at the end of the day, a judge makes a decision on the case before them, and you as counsel can present it in a way that makes as compelling a case as possible. If you focus on what's the real impact on real people of a decision like this that the judge has to make. And I think that's, when you simplify it down, what we're doing as lawyers is helping courts come up with a fair result. That's all it is. And it's not that complicated. Just have to work hard at it.
Barry, I wrote these words down right now and I will keep them written down, and I will keep using them. You win a case by the justice of the case, and the law follows. This is really deep and powerful, and I completely agree. You found a great formula that I guess many lawyers are looking for. Thank you for this.
I didn't find that. I stole it. Oliver Wendell Holmes of the U.S. Supreme Court
Yes.
was once asked, "Do you, as a judge, do you make law?" And he said, "Sure, I made 3 of them this morning." And that's what judges do, and that's what we do, and it's our contribution to society.
Absolutely. I was just looking for the Oliver Wendell Holmes book on my bookshelf, but I couldn't find it. I guess it's at home. Um, so you win a case by the justice of the case, and the law follows. Thank you for this formula, even if it came from Oliver Wendell Holmes. We stand on the shoulder of giants, but I find that we forget their names. And I thank you for reminding us their names. I thank you for telling us these stories. I thank you for this masterclass in litigation. And I can't wait to share this episode with our viewers. Thank you so much, Barry.
Thank you. Thank you, Pauletta. It's been a pleasure.